I think one of the biggest topics for business will be this very expansive and counterintuitive definition of selling of personal information. And businesses now have to get ahead around what that means to them. Potentially any sharing of information is impacted, and so they have to take inventory and see where they're sharing with other companies. We're at a time right now where the sharing of information is more important than ever before. We practice very open business models, open source code licensing, open data, maybe open cars with the connected automobiles that have to be built more modular. We need to train artificial intelligence with data. We have various new models of data monetization that have really jumped progress in the information technology sector. And so there's a lot of sharing going on, and it's being encouraged and is necessary for various purposes. And this law now restricts this sharing with very expansive disclosure obligations and also requirements to give individuals a choice whether the data is being shared under the circumstance. And you have to look not only for compliance to your own company, but to the extended enterprise, your service providers, your business partners. Many companies use cloud solutions, which by definition involve sharing of personal information for consideration, because there's some contractual clauses that will create consideration, and that is something that companies now have to take a close look at, how they want to continue that, what kind of restrictions they'll have to put on their business partners to match their own strategy on how to comply with this new law. I think that we will have to watch, while we're working on this, what is California going to do to correct some of the editorial errors. This law was passed in 6 days to form a compromise with the ballot initiative, and this was done very quickly, so there's some corrections in the works in Sacramento. People are working on that to fix that. We'll have to watch for that. And then there's also a new initiative to possibly have a federal law that could preempt the California law. That means it would take precedent over the California law. There's pros and cons for that. In the past, I think the US has been able to keep up privacy laws so well and has the most modern privacy law body still, because it was able to pass all these situation, harm, and sector-specific laws rather than have one omnibus law that can only be changed every 20 years like we have in Europe. So the federal legislation has to think about whether they want to preempt the California law, but I think there will be a drive because many perceive the definition of personal information be much too broad and undifferentiated, so we'll have to watch for that. What I tell my clients, though, is the work on preparing for this and having a strategy on this topic is not going to be wasted, even if there is a different federal law, because I don't think this is going to go away one way or another. I think companies will be held more accountable how they're sharing information with whom, and they will have to have robust contracts on this, and they have to reassess who they want to do business with and under what circumstances.